Okay, let's get started. Hi, everybody. I'm Alexandra Rizzio. Can everyone hear me? Yep, okay. I'm a senior staff attorney at the Safe Passage Project. Thank you all for coming to learn about how to represent immigrant children who are facing deportation proceedings. I know some of you, good to see you. Others of you, thank you for your interest. Thank you for wanting to volunteer. I'm glad to see a room full of interested attorneys. So thank you all for being here. Just to let you know, this is being recorded. We hope to put it on our website. I'm going to ask that everybody save questions for the end. So if you have a burning question in the middle of the presentation, please write it down because I will get to you at the end. Okay, let's get going. So, Safe Passage Project is a nonprofit organization. We're based here at New York Law School. We work with over 400 pro bono attorneys in the New York area. We closely mentor our pro bono attorneys, so we provide trainings like this one, materials like the ones you can find at the front desk up there, and we also work very closely with pro bonos throughout the life of a child's case. So we don't just hand the case over to you, we actually walk you through each step. We'll review all of your documents before you file them in court, and we can coordinate meetings, interpretation, things like that. So we have a very hands-on pro bono mentorship model. But we are always looking for new pro bono attorneys. So if you have not already signed up to volunteer to take a case, please do so on our website. We would love to work with you. So our view is that no child should face the deportation process alone. Children are not automatically appointed counsel in immigration court. So if they can't afford a lawyer, one will not be appointed to them, which is why it's extremely important that we do have volunteers working with these kids. So here's a brief overview of the presentation. I'm going to talk to you about the situation in Central America and give you a kind of background on issues related to child migration. We'll talk about how children arrive in the United States, how they're processed, arrested, processed, and ultimately released. And then we will talk about removal proceedings, what those are, what it means, and what relief from removal could be. Specifically, we'll talk about two forms of relief from removal: special immigrant juvenile status and asylum. So I'm sure you've all seen the news relating to the dire conditions in the Northern Triangle of Central America. Honduras, Guatemala, El Salvador are some of the most dangerous countries in the world right now. They regularly compete for the title most dangerous peacetime country, but I put peacetime in quotes because truly some areas of these countries are at war. We are seeing violent international narco-trafficking gangs basically come up through. There are, because of decades-long civil wars, specifically in El Salvador and Guatemala, there is really a dearth of leadership at the government level, and there's a power vacuum in many areas. So what has happened is dangerous elements have kind of taken over certain areas of the country and are really terrorizing the local population. Many of these gangs focus specifically and purposely on children. So they do that because the children are vulnerable, because perhaps they're easy to control. They threaten the kids to join the gang, or their families will be murdered. In many situations, children's families have already moved to the United States. So we have many situations where kids' parents have come to the U.S. To earn money because there's really a dearth of jobs there. So the parents are here earning money to send back home. The kids are left unprotected, and so gang activity kind of festers in that environment, and children are specifically targeted. There are other issues with gender-based violence, with violence against the LGBTQ community, And finally, issues of child abuse, abandonment, and neglect that are not well addressed by local government. So that is the context in which many children are living or attempting to live their lives. So, as I mentioned, some of the push factors, reasons that a child might flee their country, violence is, I would say, the number one. General instability, extreme poverty, resulting in children needing to perform child labor, of course, forced gang recruitment, and then lack of strong government institutions to prevent these issues. Some pull factors, why children specifically come to the United States as opposed to a different country, is they might have family here or established contacts. The New York City area has a large Central American population, so that explains why children would specifically want to make their way to New York City, and a view of the United States as a beacon of safety. So the result is that over the last 4 or 5 years, we've seen a serious increase in the number of kids who have fled the northern triangle of Central America and arrived at the US-Mexico border. Before I go any farther, I just want to note some definitions here. I will explain these as I go, but a UAC stands for unaccompanied alien child. I don't love that term. I think it's dehumanizing, so that's the legal term. It's a legal term of art, but I'll probably refer to an unaccompanied child or an unaccompanied immigrant child. We'll talk about notices to appear, an NTA, that's the charging document in immigration court that initiates removal proceedings against a child. You've all heard of ICE, Immigration and Customs Enforcement. OCC is the Office of Chief Counsel, that's the legal arm of ICE. And a TA is a trial attorney who works for OCC. EOIR is the technical name for immigration court. It's the Executive Office of Immigration Review. And an important statute to know is the Immigration and Nationality Act. Okay, so it's important to know the definition of unaccompanied alien child or unaccompanied child. The statutory definition is someone who's under the age of 18, who has no lawful immigration status in the US, and who doesn't have a parent or a legal guardian in the United States. So this definition is important because UCs get certain protections under law. So Congress has seen fit to say that if a child arrives at the US-Mexico border, they're not accompanied by a parent or a guardian, that child deserves special protections that maybe might not apply to an adult, for example, who's attempting to cross the border. I'll describe some of these protections later on, but just keep that in mind. So this chart summarizes the stark increase in the number of unaccompanied kids arriving at the US-Mexico border. These are CBP numbers pulled from CBP, Customs and Border Protection. So you can see that starting around fiscal year 2014, there was a massive jump in the number of kids arriving at the US-Mexico border. And again, that has mostly to do with the fact that the countries in the Northern Triangle were essentially imploding at that time. Those numbers have stayed relatively steady. I mean, we're not obviously at the 70,000 number that you see from 2014. It's tapered off a bit, but it's certainly an increase from earlier in the decade. So a question that a lot of people ask is, okay, I understand that the children are in danger in their home country, but why can't they just enter the US legally? Why do they have to come to the US-Mexico border and ask for admission there, or why do they cross the border and are ultimately picked up by CBP? The truth of the matter is there are no other legal avenues for a child facing danger, specifically in those areas, to make their way to the United States. They're not going to get a tourist visa. For example, USCIS, the State Department that administers the granting of tourist visas, they're going to look for things like stability in their home country. Does the person have a job or a parent or someone that they are assured that potential visitor will go back to? These kids don't have that. Most of the children who do have family in the United States, those family members don't have legal status. So the family members can't petition for them to get a family-based visa. You've heard certainly of refugee processing in other parts of the world. So, of course, you've heard about refugee camps in Jordan, various areas in the Middle East. Thailand has camps where people, previously fleeing Burma or Cambodia would reside, and UN agencies would process these people and figure out which country in the world would be willing to accept them. That's the refugee, how refugees are processed. That doesn't exist anywhere in Central or South America. So there is no independent external refugee process in Central or South America. So it's not like a child can go to a camp in Mexico or Costa Rica or something like that and say, hey, I'm a refugee, I need you to place me somewhere other than my home country. That doesn't exist. UNHCR, the UN High Commission on Refugees, does have a small presence dealing with Nicaraguan political refugees, but it's really just a humanitarian outpost. They're not actually processing refugee visas in that area. So kids are left with no other real option. There was, for a brief time during the Obama administration, something called the CAM program, Central American Minors Program. It was very limited, and it was very slow. It was limited because kids could essentially be processed as refugees if they also had a family member who had legal status in the United States. So the family-based immigration process can take years. This was intended to speed that process up a little bit, and there is the added requirement that the child also be a refugee. So that's a pretty limited number of kids who are going to qualify for that, where the parent has legal permanent resident status or is a citizen. I think only something like 800 children ever made it through that process. And it was since eliminated by the Trump administration, so it doesn't even exist anymore. So that's kind of an overview of the difficult legal path to status for kids. There's really no other way for them to approach the US and ask for protection or ask for relief other than crossing the border, unless they are able to somehow obtain something like a tourist visa, which again is very unlikely. Okay, so what happens? A child has made the difficult decision to leave their home country because they just don't think it's safe for them to stay where they are. They take a harrowing journey through various countries in Central America and through Mexico, and they arrive at the US-Mexico border. What happens? Kids actually often turn themselves in to Customs and Border Protection officers. They are, at that point, because they're over the border, they're on US soil, they're arrested and taken to an immigration detention facility, so an ICE detention facility, which is essentially a jail. There is a consent decree that came about as a result of litigation in the 90s called the Flores litigation that says that the government can't detain children in ICE detention facilities indefinitely. In fact, the government has an affirmative duty to place those kids in the least restrictive setting possible. So what that means is that kids are generally detained, they can't be detained in an ICE jail for longer than 72 hours. They're then transferred to the custody of the Office of Refugee Resettlement, which is an arm of the Department of Health and Human Services. So they're moved to this Office of Refugee Resettlement facility, which could be a group home, it could be a child welfare agency in really any state in the nation that has a contract with ORR. At that point, the child could be in this ORR facility for weeks or months as ORR looks for someone called a sponsor for that child. A sponsor is not a legal designation, it's simply a person in the United States who's willing to take that kid in. It's usually a family member or a family friend, and ORR does background checks on potential sponsors. So if a child is at an ORR facility, they'll be asked, hey, do you have any family member or family friend that you can call who might want to take you in? And hopefully the child has a phone number memorized and knows the name of their auntie in the Bronx. And ORR will call that person, send them a packet of documents, and then begin this sponsorship process. It's pretty involved. The background check is thorough. Everyone in the household has to be fingerprinted. So on the one hand, having a thorough background check is a good idea for obvious reasons. But we have seen, because the current administration has really ramped up both ICE enforcement and this particular type of background check, we are seeing kids stay in ORR detention for much longer than we have seen previously. We have also seen, unfortunately, potential ORR sponsors be picked up by ICE. So you don't have to have legal status in the United States to be an ORR sponsor, and in the past, that wasn't an issue, but now we're seeing ICE share information, we're seeing ORR share information with ICE occasionally, so that potential ORR sponsor is themselves arrested, and then they're in immigration detention and the child is in immigration detention. So that is problematic from the standpoint of ultimately releasing the child to the least restrictive setting. They're still in a child welfare agency. Eventually, the goal is that the child is released to this sponsor, and the child is transferred to whatever location the sponsor lives in. So if the sponsor lives in Nebraska, the kid's going to Nebraska. If the sponsor lives in the Bronx, the kid is going to the Bronx. At that point, ICE will usually, Immigration and Customs Enforcement, will usually file a document called a Notice to Appear, an NTA, with the immigration court that has jurisdiction over that location. So say a child is released to a sponsor in New York, ICE will file a Notice to Appear in the New York Immigration Court over here at 26 Federal Plaza, just a few blocks away. The filing of that document with EOIR, the immigration court, is what initiates removal proceedings against the child. I mentioned this earlier. It's important to note that being released to a sponsor is not a legal designation of guardianship or custody. So guardianship or custody is dictated by the state where the sponsor lives. This sponsorship designation is simply the government at the federal level saying, we're going to send a kid to live with you. It's your responsibility to make sure that they appear at immigration court. You're supposed to take care of this child. Thank you and goodbye. There's no real ongoing legal responsibility that attaches. So as I mentioned, ICE will file this Notice to Appear in immigration court, and soon thereafter the child will be issued a hearing notice separately from the immigration court saying, show up to court and answer the charges against you. You're in removal proceedings. And I will just in one or two slides talk about what happens then, but I do want to mention some concerning developments. Recently, the Trump administration has made known its plans to eliminate the Flores settlement. So you'll recall here, do I know how to use the pointer? I do, okay. So here, per the consent decree in Flores v. Reno and subsequent litigation related to that consent decree, kids are only supposed to remain in detention in the most restrictive setting, ICE detention, for 3 days. They're then supposed to be released to a setting that is less restrictive. The Trump administration has said that it wants to eliminate the Flores settlement by enacting certain regulations out of DHS. I don't know how that would work because it's a settlement agreement between two parties, right? I don't know how you just eliminate a legal settlement, but the administration clearly doesn't necessarily see itself as bound by certain rules and regulations related to the treatment of children at the border or soon thereafter. That is concerning. We've seen, obviously, the building of tent cities in Tornillo to house unaccompanied immigrant kids. And, of course, the family separation issue Last summer, we've seen in multiple ways how the administration wants to deal with immigrant children, and it has advocates very concerned. Okay, so children are placed into removal proceedings. I mentioned that ICE has to file an NTA, a notice to appear, in order to initiate these proceedings against a child. This is essentially the charging document. So the point of this document is that the government is alleging certain things against the child, and if those allegations are true, the child would be removable from the United States. So the allegations are things like, you are not a citizen and national, do I have this right? Yeah, you are not a citizen or national of the United States. You are a citizen and national of Guatemala. You arrived in the US on a certain day at a certain place, and you were not then admitted or paroled, meaning you crossed the border, but you did not have permission to do so. A CBP officer did not inspect you at a port of entry. You didn't have a visa to cross the border. Therefore, you are removable under a certain provision of law. Most likely it's INA 212A6A1, which is an alien present in the US without admission or parole. I'm going to go off on a brief tangent here. I hope you'll bear with me. This, I think, right now is the most interesting part of an NTA. This part here, if on my sample NTA, it says you must appear at immigration court on a date to be set. It literally says date to be set, at a time to be set, to answer the charges against you. Why is that important? There is a recent Supreme Court case called Pereira v. Sessions. This case was decided in 2018. I think it was June of 2018. June of 2018. This was an 8-1 decision, and I find this decision fascinating, and I'm going to explain why. Basically, the regulations, the INA, the Immigration and Nationality Act, and the regulations enacting it say that in order for jurisdiction to vest with the immigration court, so in order for the court to have control over whether or not a child is removable from the country, or anybody is removable from the country, a charging document must first be filed. So this document must be filed. That's pretty self-explanatory. There's a definition of charging document in the regulations. And it says, there's like a 10-point list of what is a charging document. It has to be labeled charging document or notice to appear. It has to have a bunch of things. It has to list the allegations. It has to list the charge. It has to list the date and time that the person must appear in immigration court. Well, that's weird because we have about 1 million NTAs that say on a date to be set and a time to be set. What does that mean? I think it means that all NTAs that look like this, which is basically any NTA issued after 2002, I don't even know what the date is, are invalid. It has not vested the immigration court with subject matter jurisdiction over this case. That argument was successful for a certain type of case, for Mr. Pereira's case in Pereira v. Sessions, 8-1 decision. Immigration advocates, when this came down, were in a frenzy because we all said, oh my goodness, all of our NTAs look like this. We think that means all NTAs that look like this are invalid and therefore jurisdiction hasn't vested with the immigration court. I think that's a fascinating argument about subject matter jurisdiction and parsing the statute and everything like that. The BIA then came down with a very puzzling case. So someone, took that argument to its natural conclusion. The Board of Immigration Appeals, which is the essentially the appellate court, one above the immigration court, I think issued a decision that doesn't make a lot of sense, basically saying, oh, Mr. Pereira's case was basically limited to its facts. Don't go crazy. NTAs are still valid, even if they look like this. I think that's incorrect. There's basically already a circuit split on this. So I think this is a fascinating issue. It's a little procedural, it's a little esoteric, but as an immigration lawyer, I think it's really something that's interesting. And it's something that where I've gone into court and made arguments. I go into court and say, Your Honor, I am in receipt of this purported notice to appear. I don't call it a notice to appear because per the regulations, it's not one. So I say, I'm in receipt of this purported notice to appear. The judge will say, okay, are you ready to take pleadings? Are you ready to admit or deny the allegations? And I say, no, I think you should dismiss this case. It is not properly before you, Your Honor. And I have a little oral argument that I make, and the judge, who is unfortunately bound by this more recent Board of Immigration Appeals decision, respectfully denies my oral motion, and then we move on. But I think ultimately it's going to go up to the Supreme Court again. So I'm sort of making my record at this level to say that a notice to appear that is lacking the date and time information is not a notice to appear at all. Therefore, jurisdiction did not vest with the immigration court. Thank you for letting me go on that tangent. I think this is really interesting. We have some guidance on this. If you have a case right now where you haven't taken pleadings yet, you haven't yet gone to court with your client, we do have guidance on, I'm just looking at my cheat sheet. This is what I bring to court that lists the regulations and the statute. So let me know if you want to learn more about that. Okay, so removal proceedings are civil, not criminal. What does that mean? It means that Gideon does not apply. So there is no appointed counsel in immigration court. EOIR is an agency within the Department of Justice, and immigration judges are administrative judges, not Article III appointed judges. The government is always represented by attorneys from the Office of Chief Counsel. So respondents, the client, they have a right to an attorney, but if they can't afford one, they won't get one. So that's why it's so important for the private bar to get engaged on these issues, because children have and will continue to go up against an ICE attorney alleging that they should be deported back to the danger from which they fled, and without an experienced attorney there by their side to articulate the forms of relief that they're eligible for, that child will be removed. So again, thank you all for being here, because without pro bono attorneys, kids would be stuck. Okay, I'm gonna just skip by, I was gonna skip by this slide. The point of it is there are a lot of kids in immigration proceedings, but legal counsel does make a difference. So if a child is represented, they win 85% of the time. They win some kind of relief from removal. If they're pro se, if they go on their own, they're only successful at stalling their deportation about 13% of the time. Okay, so you've gone through, your client has been processed at the border, released to their sponsor. They have appeared in court and answered to the charges against them. Maybe you admit most of the allegations because they're factually true. Maybe you concede that they are in fact removable under the INA. You can do all that, and that is what usually happens. You admit and concede. There are many reasons why you might not want to admit or concede certain things. That's maybe for a more advanced training. But say you do admit and concede that the child is removable, you then state to the judge what form of relief from removal the child is seeking. So you are saying, yes, judge, under the INA, the child is technically removable from the United States, but you shouldn't remove him or her, and here's why. So there are many different forms of relief from removal. This is a brief summary of them. Some of the options on the left can lead to permanent immigration status, like a green card and eventually citizenship. We're going to focus, for the purposes of this presentation, on special immigrant juvenile status and asylum, because those are the two forms that we find are most common for our clients. And I would say, I've interviewed probably hundreds, I think probably hundreds of kids, and many, if not most of them, are eligible for one of these forms of relief. Okay, so we're going to discuss asylum first. In the wake of World War II, the UN drafted the Convention relating to the status of refugees. The US signed on to it, and then we enacted it into our own laws in 1980. So you'll see here the relevant section of the INA. The relevant definition here is that in order to be eligible for asylum, the person must have experienced past persecution, or they must have a well-founded fear of future persecution. That persecution has to have been committed by the government or by a private individual that the government cannot or will not control. The government is unwilling or unable to control that private individual. The persecution can't just be any old garden variety persecution. It has to be connected to a certain motive. So that persecution, in order to qualify the person for asylum, has to be on account of the victim's race, religion, nationality, political opinion, or membership in a particular social group. That person can't be able to relocate within their own country, and there can't be any bars to asylum. Asylum is a discretionary grant. Basically, the Attorney General has to agree that the person is both eligible for asylum and warrants a discretionary grant of asylum, so it's not available for people with certain types of convictions. So basically, this is the definition of refugee. So a refugee is just someone outside their country of origin who meets this definition. An asylee is someone who's already in the United States. So you could be a refugee in South Africa, okay? If you meet this definition, if you are in the United States, you are an asylee. So it's important to keep in mind, I think this is important for framing this discussion. You're a refugee or an asylee as soon as things happen to you that allow you or force you to meet this definition. The asylum adjudication process in the United States, it should be simply one of recognizing that the person does in fact meet that definition. So in my mind, they're an asylee as soon as the things happen to them that have happened. And it's our job as advocates, and it's the adjudicator's job as adjudicators to flesh out all of those facts and determine that the person is in fact eligible. Okay, so important points. You could already tell this from the definition, right? But asylum doesn't cover anyone, doesn't cover everyone. It's not just for people who are afraid to return to their home country because of generalized violence. It's not for people who were persecuted on account of a motive other than these here. The nexus and we call it the nexus. The motive for the persecution has to be one central reason for the persecution feared. It does not have to be the only reason for the persecution feared. So if someone has been persecuted or fears they will be persecuted on account of their religion, but they also think that they will be persecuted because their persecutor simply doesn't like them, and they can't tie it necessarily to a discrete motive, that's okay, as long as the persecution is done on account of the motive, and that motive is one central reason for the persecution, that person should qualify for asylum. So that nexus, that connection between the persecution and the motive, the persecutor's motive, is key. What's interesting about asylum is that we are asking both the victim, the asylum applicant, and the adjudicator to basically get inside the head of the persecutor. Why was the persecutor going after the asylum applicant? Your role as an attorney is to help the applicant flesh that out. As you can probably tell from the definition, which is multi-pronged and dense, case law is really important here. So there are plenty of cases at the Board of Immigration Appeals level, at the circuit level, that basically define persecution What is past persecution? What is having a well-founded fear of future persecution? What constitutes race? What constitutes religion? And then I would say most importantly, what in the world is a particular social group? I will describe what it is, but the definition is kind of squishy. So you'll see where there are potential issues in defining particular social group. So case law is super important when you're working on an asylum case. You basically need to analogize to previous case law so that you construct your argument in the most forceful way possible. Okay, so I mentioned at the beginning that the asylum definition was basically, it was drafted in the wake of World War II. UNHCR, the UN High Commission on Refugees, had a large hand in drafting it. So I look to the UNHCR guidance on a variety of, on many aspects of this definition, because it is confusing, but UNHCR was the one that drafted it initially, so I think their guidance is instructive. Okay. I'm going to talk to you a little bit about particular social group. What does it mean to be persecuted on account of your particular social group? Well, UNHCR says that if you're being persecuted by someone because of your background, your habit, or your social status, for example, or if you're being persecuted by the government because the government views you as part of a group that is not loyal to that government, or you are a member of a group that shares a common immutable characteristic, or, and this or is important, or you're a member of a group of people who are perceived as a group by society, perhaps you meet the definition of someone who's been persecuted on account of your membership in a particular social group. Okay. Things start to get confusing when we look at Board of Immigration Appeals case law on PSGs, because the BIA has sort of veered away from the UNHCR guidance and has ended up creating additional requirements that we need to be aware of. So the foundational case related to persecution on account of membership in a particular social group is matter of Acosta. If you take an asylum case, I would say like number 1 or number 2 case that you should go read is matter of Acosta. So the idea here from 1985 is that if you have an immutable or a fundamental characteristic, like your sex, your color, your kinship ties, you can't change your kinship ties, right? Like who you're related to, or if you have a shared past experience and you're persecuted on account of those things, you are persecuted on account of your membership in a particular social group such that you qualify for asylum. Okay. Throughout the years, the definition has gotten a little bit muddier. So we have in 2014, there are a series of like companion cases at the BIA dealing with specifically gang recruitment. So this is important because, as I mentioned at the outset, a lot of our clients are fleeing their home country because they are targeted by gang members, right? So we want to know how the BIA and other courts have dealt with gang membership claims and particular social group. So this case, matter of MEVG from 2014, the board is essentially adding requirements beyond the UNHCR definition. So not only to be a member of a PSG, not only do you have to have an immutable characteristic, but your group has to be socially distinct, such that society considers the group to be a distinct group. So you're looking at what society thinks of your proposed group. That's a little complicated. And you have to be able to see whether someone is a member of that group or not a member of that group. So if you'll look back to the UNHCR guidance, it's an either-or definition. Either people share a common immutable characteristic or people are perceived by society as a member of that group. The BIA has made it an and. So that really makes it more difficult to show that you're a member of a particular social group that was persecuted. And I think it's problematic under our obligations under international law, right? Because we promulgated the relevant provisions in the INA because of our responsibilities under the Convention relating to the status of refugees. So where does that leave us? There's a lot to prove when you're trying to show that someone is persecuted on account of their membership in a particular social group. Well, what can we do here? How do we show, for example, that the group that the client says that they're a member of is actually a group at all? We could get some expert opinions on what society thinks. We could go to a scholar or someone who lives in that country to say, hey, does group X, sound like a group that people know about? In some cases, that's straightforward, right? In some cases, the person could say, I'm a member of the LGBTQ community, and I have been persecuted, or I fear persecution. I think there's plenty of evidence that in certain countries in the world, members of the LGBTQ community are in fact viewed as a distinct group in society. So I don't know that we would have too much work to do there, but if it's another type of group where maybe there's not as much information about who's a member and who's not, getting an expert opinion could be really helpful. So the PSG designation the definition is quite complicated, and it's no longer really parallel with the other grounds. For example, if my client claims to have been persecuted on account of their religion, I don't have to show that their religion is viewed as a distinct religion in the society where they live. It's just simply not a requirement. But with a particular social group, it is. The particularity requirement, so determining who is a member of the group and who's not, again, not really required when we analyze the other grounds like religion, like race, like nationality, but with PSG it is. And like I said, society's view is considered here, unlike just the persecutor's view for all of the other grounds. So some PSGs that are actually recognized in case law, I mentioned sexual orientation, family or clan membership, former status. So for example, I guess an example would be someone who was who had a former job, former bus driver could work, but MEVG carved out an exception. Gang membership, former gang member, is not a particular social group. I find that kind of problematic legally because the facts on the ground are that if someone is forcibly recruited into a gang, they're branded, they have to undergo certain hazing, and then say they want to escape. It is extremely difficult to extricate oneself from a gang, but say someone manages to do that, they are oftentimes targeted by their former gang members for persecution. But matter of MEVG says, well, former gang membership doesn't meet the definition of particular social group. I think if we're doing a rigorous legal analysis, it should, and yet the BIA has found that it does not. Keep in mind that when you're analyzing PSGs, it's totally dependent on your client. So I mentioned that case law is important. It is important, but your client could be the first member of a group that was persecuted in their home country. You should simply analogize to other cases that are already on the books. And it's also your job as an advocate to explore certain country conditions evidence so that you get a better sense of the situation on the ground for your client. Okay, importantly, family can be a particular social group. What do I mean by that? Say a parent owns a store. Okay. What often happens, we see this time and again, gang members come to the store and say, you have to pay me la renta. You have to pay me rent of $300 a month or we'll kill you. Okay, that is a very serious threat. However, the dad, the owner of the store, is probably not eligible for asylum based on that alone because what member of a particular social group is he? What PSG does he belong to? Business owners? Maybe. That's kind of a hard sell, and it hasn't really worked at the BIA level. However, say the gang member comes back the next month and says, okay, if you don't pay me la renta of $300, I'm gonna kill you and I'm gonna kill your kids. Whoa, okay. Kids might actually have a claim here because, and this is just a quirk of asylum law, the kids might have a claim because of their relationship to dad. So, is their relationship to dad an immutable characteristic? Yes. They are children of their father and they can't change that. Is being members of a nuclear family a socially distinct group? Probably. If you're out and about with your family, you're going to church, you're going to the store, you're walking around in your community. A nuclear family member could be, your nuclear family could be socially distinct. Is that group particular, your nuclear family? Well, sure, you can figure out who's a member of that family and who's not, right? So we've just done the three-pronged test that Matter of MEVG sets out, and the child might actually be eligible for asylum as a member of a PSG because of the threat to dad. And I should explain this GIF, which is its sister Sledge doing We Are Family. Okay. So even if dad is threatened and that threat does not make him a member of a protected, of a PSG, his kids, because of the threat to them and their relationship to their father, might be members of a PSG. So I think that's an interesting quirk of immigration law, but it fits with the definition. So like I said, this is always a case-by-case analysis. The adjudicator is always supposed to go prong by prong through the test. So, there are lots of, there's case law about that case-by-case determination. Okay, so I'd like to do a brief hypo. I'd just like to take, what time is it? Okay, we're okay. Take 2 minutes and read this. I'm gonna read it out loud just in case the video doesn't capture the text on the screen. So Francisco is 16 and he's from El Salvador. He lived on the streets because his parents abandoned him. He refused to join the MS-13 gang, so the gang beat him and tattooed the number 13 on him. But he still refused to join and got death threats. He did not report the crime to the police because they thought they wouldn't believe him because he had a 13 tattooed on his body. Francisco fled to the US and he lives here with his aunt now. So just take a minute and analyze this. Think about, I'm gonna go back to the definition here of asylum. Here we are. Do you think that Francisco meets the definition of an asylee, and why? So just take a minute. Okay, does anyone have any ideas as to whether Francisco might meet the definition of asylee and why? Just shout it out, don't be shy.
Seems like he doesn't.
And why not?
Because he 1, 2, and the last 2, he's in. But if I remember what it said right, it's not his race, religion, nationality, political opinion.
Right.
So the question is whether he's a member of the PSG.
Right.
I think you said before that being pushed into a gang is not that. So he's not in good shape.
So yeah, interesting. I mean, I think you're right on. He did suffer past persecution. He was beaten. The persecution was done by a private individual that we know based on, common sense and general knowledge of the situation on the ground. The government is unwilling or unable to control MS-13. I'm going to pause on this Nexus question. In general, and I didn't tell you this before, so you wouldn't have known, but when it comes to kids, internal relocation within a country is generally not reasonable. Like if he's a 16-year-old kid, in most cases, an adjudicator would not find that he should have picked up and moved to a different city. And I didn't give you this information in the hypo, but let's assume that he doesn't have any bars. So yes, the question is there a nexus here? Was his persecution on account of his race? I don't think we have any information about that. Religion? No info on that. Nationality? Probably not. I'm going to pause on political opinion, and I'm going to pause on PSG. So let's go back to the hypo. There, okay. So he refused to join the gang. The gang beat him and tattooed 13 on him. He still refused and got death threats. So in general, if he had been a former member of a gang, I told you that MEVG, the case, said that, well, that's not enough. Being a former gang member and then being persecuted on account of that does not constitute a PSG. I think there are some ways that we could look at this information and say, maybe he was persecuted on account of his membership in a particular social group. And here's what I think. He lived on the streets because his parents abandoned him. Okay. That's salient information, right? Because is it possible, and we would have to talk with Francisco about this, and maybe we would want to talk to an expert on gang recruitment, for example. Is it possible that he was persecuted specifically because he was a street child, right? So did the gang see him and say, kid with no parental protection, all alone in the world, he seems like a juicy recruit for us. Is that is being a street child membership in a PSG? Is it immutable? We could make the argument that that's immutable. He didn't choose to be homeless, right? Like his parents abandoned him. Is he socially distinct? I would say probably. It's sometimes easy to see, who is homeless and who is not. What else can we look to for social distinction? We could look to laws within the country related to homelessness. Like, does the country itself recognize homelessness or street children as potentially being a problem that deserves attention? Maybe that's a good indication that it's socially distinct. And is the group particular? Yeah, probably. You can make an argument that it's that you can define who is a member of the group street child and who is not. So I would say maybe we have that as an option. It gets a little bit more complicated when we have this gang analysis. So he said that he couldn't go to the police because he thought they would not believe him due to his tattoo. Is it possible that his refusal to join the gang, questions that I would want to ask him are, was your refusal to join the gang based on your religion? Like, are you Christian and it's against your religion to steal and do drugs and other things like that? And did the gang know about that? So that's a question that I would ask. Was it related to a political opinion? Does he, in the area where he lives, does the gang essentially operate as a de facto government? Like, there are gangs who are charging taxes on people. There are gangs who essentially run, I don't want to call them social services, but they run everything in that neighborhood. Was his refusal to join because of a strongly held political belief that the gang is terrible? We have had cases like that where our client says, they really were the de facto government in our area, and I so strongly disagree with them that I was on the street preaching against them. That's information that I would want to know from Francisco. So I think here we have a possible PSG of street children, and we have some questions that we want to ask to get more information from Francisco. Okay, so I mentioned gang resistance as political opinion. There's some case law that actually backs that up, and so we would want to ask our client some questions related to why he refused to join the gang. And I also mentioned religion or politics. Another theory that I find really interesting and that is borne out by the experiences of our clients is feminism as a political opinion. So for young girls who are threatened by gangs, It often takes the form of them being forced to be so-called gang girlfriends, which is really just forced sexual slavery. And many times, young women would stand up to the gang and say, no, my body is my own, and you can't have it. That is a form, certain clients express that as a political opinion. Their bodily autonomy is important to them. And that's why they refuse to do whatever was demanded of them. So that's a theory that I think is worth exploring. Okay, so one of the handouts that you see at the front, if you don't have it now, feel free to take it at the end. It's also on our website. There have been concerning developments regarding gender-based persecution. So just to give a quick history, matter of ARCG was a case decided by the Board of Immigration Appeals in 2014. So after many years of fighting about this particular case, the BIA finally recognized the following as a PSG: married women in Guatemala who are unable to leave their relationship. So basically what this is women who are viewed as property by their spouses, who are trapped in abusive relationships due to societal and cultural norms, and who don't get any protection from the government. The government refuses to intervene in so-called family situations. So obviously, the Board of Immigration Appeals is the appellate level above the immigration court. At the immigration court level, and of course at the asylum office, which I'll describe in a bit, adjudicators were granting asylum. They were granting asylum to applicants on the basis of gender-based violence for years, but this BIA case establishes that as precedent. So there was really no consistency, and there was a long fight starting in like 1999 or even before that, 1996, about whether really like gender-based violence and women viewed as property could constitute a particular social group for the purposes of asylum. So ARCG kind of codified that. And just a little reminder, you'll see why I'm explaining this in a minute, but EOIR is the immigration court. The Board of Immigration Appeals is the appellate division. If you don't get your case granted by the BIA, you can appeal up straight to the Second Circuit, so you bypass the district court, and then you can go to the Supreme Court. So what happened in a case last summer is that then Attorney General Jeff Sessions interceded in a case at this level. He can do this. He can certify certain cases to himself. So because essentially EOIR is a branch of the Department of Justice, he has the ability to, if there's a case sitting at the BIA, he has the ability to certify a case to himself and say, this is now my case, I'm gonna decide it. And that is what he did in a case called Matter of AB. So an IJ, the procedural background here is an immigration judge in North Carolina denied a gender-based asylum case, even though it was after Matter of ARCG, and obviously the applicant and her attorney thought that she deserved asylum, so they appealed it. The BIA reversed the IJ and said, hey, look at Matter of ARCG, we already went through this, and ordered the judge to enter an asylum grant. The IJ refused. I don't know how the IJ refuses an order from the appellate court above it, but he did. And he referred the case, he just sent it back to the BIA and said, nope. And so the BIA is sitting with this case like, okay. At that moment, Jeff Sessions certified the case to himself, and then asked for briefing. This is the issue that he asked for briefing on, whether being a victim of, quote, private criminal activity is a PSG. It's not a PSG. It's never been a PSG. The PSG that's proposed, that Ms. AB was relying on, is the PSG articulated here in Matter of ARCG. Married women in X country unable to leave their abusive relationship. Women viewed as property, essentially. So he was from the gate starting from a position that gender-based violence does not qualify someone for asylum, which I find extremely problematic given the actual country conditions on the ground and the relevant case law. Even DHS said to then AG Sessions, maybe this is not the case that you want to get involved in, but he did anyway. He issued a decision in June called Matter of AB. Matter of AB does a lot of things, but it's important to separate the holding from the dicta. So the holding was Ms. AB did not win asylum. And the holding was the PSG articulated in the other case, Matter of ARCG, is not a cognizable PSG. He then goes on to say a lot of other things, including that for someone to win asylum based on persecution by a private actor, the government has to have condoned that persecution, which is not what case law says and it's not what statute says. Actually, it's that the government has to be unwilling or unable to protect the individual. So he can't just rewrite statute, right? So that's dicta. And we think, there is, well, it's very clear actually in a lot of the language is that he wants judges to expand their use of judicial discretion in order to deny asylum cases. So UC Hastings Center for Gender and Refugee Studies did a very good analysis on this and said that one of his likely goals, in addition to restricting asylum for victims of gender-based violence, is also to expand that restriction, if that makes sense, to preclude asylum in other cases that could be analogized to gender-based violence. So any other case, for example, where non-state actors persecute individuals, including children and LGBTQ applicants. So that's a concerning development. The practice advisory that's on our website and that's on this table offers some strategies for arguing against Matter of AB, and there are some other really good practice advisories online. So I'd like to shift for a minute into how do you handle an asylum case? What is best practice? First of all, you're going to want to talk with your client and figure out what their story is. You need to draft an affidavit from your client. So it might take several meetings for them to open up to you. Oftentimes, people with asylum claims are understandably traumatized. So working with them in a non-adversarial way to learn everything that you can about them, and then serving as their advocate, helping them tell their story is essential. As their attorney, you're going to want to gather country conditions evidence, especially when you're working with kids. Like, they might not be able to articulate all of the reasons why a persecutor is persecuting them, right? So it's important for you to know, okay, I know that the client is a member of Garifuna, for example. It's an ethnic minority in Honduras. I know that, so let me look into treatment of Garifuna in Honduras, because the client, who's age 11, might not know anything about historical persecution of Garifuna in Honduras, right? So that's your job. So gather country conditions evidence that you can then, put in your asylum submission. It's important to consider getting medical or psychological evaluations, because that serves, first of all, as corroboration of the client's story. And second of all, it can address any issues that the client has when telling their story. So if the client is, suffering from severe PTSD, has head trauma, and is unable to remember dates, times, important facts about their case, it's important to document that, because the adjudicator needs to know, it's not because the client is lying that they can't remember the month that this happened in. It's because they actually have head trauma or PTSD that's preventing them from doing that. If the client has physical scars, it's important to document those as well. So there are medical professionals who can examine a client's scars and say, client told me that he got these scars because he was burned in a ritual pattern with cigarettes. I looked at the scars and they are consistent with cigarette burns. So things like that, you could include pictures of the wounds, for example, in the asylum filing. And finally, I've mentioned this already, but this is especially important if you're working with a case where the client was persecuted on account of membership in a particular social group. That social distinction prong can be hard to prove, but you can do your own research, and you can also engage with scholars on similar matters and solicit an expert opinion. We need to focus on the nexus. So what is the persecutor's motive for persecuting your client? Why did they go after them? How do we know it? How can we prove it? Be careful when you're formulating a PSG, really when you're articulating any nexus, but particularly the PSG that has those complicated prongs, how we frame and how we articulate why the persecution happened is very important. Of course, keep in mind, new case law developments, and this is where your Safe Passage Project mentor comes in also. Respond to matter of AB, respond to new issues that will no doubt arise in the coming years. And finally, and this is perhaps the most important, help the client navigate their trauma. So don't expect your client, who's a young person, to be able to tell a coherent and concise history of themselves on the first go-around. It's not going to happen. You have to expect that it will take time, that you'll have to work with them in order to elicit the information necessary to put into an asylum filing. Okay, so you may have heard me say, I mentioned at one point something called the asylum office, and then I also mentioned immigration court. People who are not in removal proceedings can file their asylum application first with the asylum office. So the asylum office is a branch of U.S. Citizenship and Immigration Services, USCIS. That affirmative filing process is a benefit that is, basically the asylum office is supposed to be non-adversarial. So if you are a client going into an asylum office for an interview, there's no judge, there's no ICE attorney there, it's just you, the client, the asylum officer, who's supposed to have been trained in trauma-sensitive questioning, and hopefully an attorney and a translator. So when I say non-adversarial, it's the asylum officer's job to get information to determine whether or not the client qualifies for asylum. It's not a cross-examination. It's not supposed to be very contentious. It's just supposed to be an opportunity for a client to tell their story. If the person is not filing affirmatively, meaning if they are in removal proceedings, they don't get the benefit of going to the asylum office. They have to go straight to the an immigration judge for like a full trial. So in that situation, if you're already in removal proceedings, you're filing what's called defensively, and you will have a hearing with an ICE attorney there. The judge is sitting on their dais in the robes. You have your attorney at the respondent's table. The applicant will answer. You can ask, as the attorney, ask direct questions, and then the ICE attorney will cross-examine that person, basically in an attempt to discredit them. That is obviously a much more stressful process, right? That is the process for adults. Affirmative, not removal proceedings, asylum office; defensive, in removal proceedings, asylum trial. Unaccompanied alien children, UACs, that I gave you the definition earlier, get the benefit of having their case heard first at the asylum office, even though they're in removal proceedings. So that's a pretty big benefit that our government, where our government has said, look, kids shouldn't have to go straight to a full trial. That doesn't seem fair. That seems really stressful for them. If they were designated unaccompanied alien kids, UACs, we're going to let them first go to the asylum office. If the asylum officer thinks that they don't meet the standard, then they can refer them back to court, and then we'll have a full trial on their asylum eligibility. There are some concerning developments about asylum filing procedures for unaccompanied kids. So keep in mind the definition. It's that you're under the age of 18, you have no lawful immigration status, and there's neither a parent nor legal guardian in the United States. That designation essentially attaches when the child crosses the border, when the government is doing their initial assessment of this kid. So if the child is designated a UAC at or near the border, that designation was previously supposed to stick with the kid. So there's a May 2013 memo that says that a UAC is a UAC until that designation is affirmatively stripped from them by DHS, ICE, or CBP. So even if a kid, back in 2013, even if a kid turns 18, even if they're eventually reunited with a parent or guardian in the United States, if they were designated a UAC at the border, they're still a UAC. They get all the protections of filing their asylum application in the way that I just described. But new developments. There's a policy memo from 2017 that says that immigration judges can inquire into UAC status, with the notion, I guess, the implication is that they can then rescind that UAC status. I'm unclear on the authority for that, but the text of the memo, I think this is a really interesting memo. You should Google it if you can. It's a policy memo dated December 20th, 2017. The language is instructive. It says, judges should ensure that an alien claiming to be a UAC is in fact a UAC at the time his or her case is adjudicated, and it goes on to mention a lot of issues of fraud. So basically is this child before you truly a child? You should look into that. There's a lot of other concerning language in that memo that I think is instructive, but not directly on point. So then, in 2018, the Board of Immigration Appeals issued this case called Matter of Mako that says if someone who was previously designated a UAC turns 18, poof, they're no longer a UAC anymore. They don't need to have their status affirmatively rescinded. They just are not a UAC. They can't file with the asylum office. The end. They're going to have a trial before the immigration judge. So that's a very distinct, essentially policy change, a change in how this definition is read and applied. Okay. I'm going to pause there. Actually, I know I said I'd save questions for the end, but I just gave you a lot of information about asylum. There are entire law school classes on asylum and refugee law, so thank you for bearing with me. Does anyone have any questions now on asylum? If you don't, we can save them for the end. I'm sure you do, unless that was just so super clear that. Yes?
You mentioned getting experts
Yes.
to bolster your case. Are these experts paid? Are they volunteers?
That's a great question. I'm just going to repeat it. So I did mention obtaining experts to support an asylum filing. Are they paid or are they volunteers? Hopefully they're volunteers. We don't have a separate budget to pay an expert. What I have done in the past, there are different approaches to this, but in the past, if I found an article, for example, that I thought was super helpful and on point, written by a researcher, I would email that person and say, here's what I'm doing. Do you have anything on point, or would you be willing to draft a very brief statement for me and for my client? Or I'll talk to them on the phone for, a half an hour to an hour, and then draft it myself and send it to them for edits, just based on everything that they've told me. So those are options. Generally, we, as a nonprofit, we don't pay them. If you work for a firm, for example, that has a pro bono budget, we could consider utilizing that budget for that purpose. But yeah, as an initial matter, no, we don't pay them. Other questions? Yes.
Same question with respect to translators.
Okay, great question. So do we pay translators? So there are a number of different points where we're obviously going to need documents translated. Safe Passage Project has a lot of our staff is bilingual, and we employ college interns who are bilingual specifically for translation help. So if you have like a birth certificate or an article or something that you need translated from Spanish to English, we will assign it to one of our interns, and then it's reviewed by a paralegal or an attorney. So that's how, at the Safe Passage Project level, we get things translated. Again, if you work for a big firm, usually there are resources within the firm to pay for a professional translator. But as long as the person attests, swears under penalty of perjury that they're fluent in English and Spanish and they translated it to the best of their ability, that's acceptable. It doesn't have to be, a professional translation service that's certified by the court or anything like that. Yes?
Translations and interviews.
Yeah, so, what about translations at interviews? So if you're meeting with your client at Safe Passage Project, we can provide interpretation services. And likewise for the asylum interview, the client is required to bring their own translator. So the government does not provide a translator, so we work with the client to arrange for, so our bilingual college interns or one of our staff will go with the client. There is, interestingly, the government does pay for something called a monitor. So when you're sitting in the asylum office for the interview, it's attorney, client, interpreter, officer, and then on the phone, there's someone who's monitoring the interpretation to ensure that the interpreter and the client are like not in cahoots, that the interpretation is accurate. Yeah. Other questions? Yes.
In the hypothetical,
Mm-hmm.
when you were going through the definition of refugee,
Mm-hmm.
you mentioned that there was a possible unaccounted political opinion argument.
Yeah.
Did you go through that, and I started that?
Yeah, a little bit. So the question is related to political opinion arguments as they relate to gang-based cases. So I did mention that in certain situations, gangs truly operate as de facto governments in lieu of any functional or functioning government. They do things like collect taxes. They claim that they provide protection in certain areas. In lieu of strong actual government institutions, they're really the only operating system there. So I think it's a bit of a novel argument, but I think it's accurate based on the situation on the ground and based on case law and applicable statute. So if the client specifically did not want to join the gang because they view them as unsavory for political purposes, like they have an objection to the things that the gang does, that's a potential argument. I don't know if it's a winning strategy, but I think it's one that we should consider for sure.
And in that case, would the respondent have to vocalize to the gang that he's opposed to gangs? That's
Right, great question. So does the client have to actually vocalize their political opinion to the gang or to anyone else for that to work? I don't know. It's going to depend on the adjudicator. There is something called imputed political opinion. And there's also imputed membership in a particular social group. So if someone thinks that you have a political opinion, even if you don't have that political opinion, or if someone thinks you're a member of a group, even if you're not a member of that group, there is case law that says that that person can still qualify for asylum. So, if you have done something, to use a more straightforward example, if you have done something to somehow indicate to a persecutor that you're a member of a political party, but you're not actually a member of that political party, maybe you're agnostic as to whether that's a good party or a bad party, but you're persecuted on account of their belief that you're a member of that political party, even though they're mistaken, you might still qualify for asylum. So it's not necessarily is the answer, but it's a bit of a nuanced argument, but I think it's one that can be made and made successfully. But a lot depends on the adjudicator, to be honest. Okay, yes.
Have you had the experience of UACs coming and having been or appearing to have been counseled in their home country as to making their narrative comport with the requirements of asylum seekers?
I do not see that very often, really at all. I hesitate to say ever, but really no. The requirements are so stringent. The law is ever changing. And frankly, I get to know these clients over a period of months and years. Their stories as they are very compelling. So I have not come across that. I think really we're looking more at nuances of the application of the law itself in an ever-changing environment. and getting the client to open up. I think that's the real issue, is getting the client to tell you all of the terrible things that have happened to them, because they're so disturbing oftentimes that I don't come across your example very often. Yes.
What's the youngest age typically that, would be fine?
Yeah, so I have represented a 2-year-old, and I've represented, we accept cases up until age 21. So, I've represented like 21, 22-year-olds if they turn 21 or 22, but I would say typically it's between the ages of like 11 and 17 are the majority of our clients. Sorry, her question was, what are the ages of the clients that we represent? Yes.
How are the children referred to safe passages or cases?
Yeah. Great question. So basically, there are many different ways. We go to immigration court, specifically on days where we know there will be juveniles appearing, and we tell the judges know us. So we say, Judge, safe passage is here. If you have an unrepresented juvenile client, will you please direct them to me? I'm standing outside the courtroom with a clipboard. So that's one way, when they appear at their first, what's called a master calendar hearing. And the judge generally grants them time to obtain legal counsel. So we'll meet them at court. We get referrals from other organizations, and we also get referrals from basically directly from the border. So when a child is being sent, when ORR is processing the child, and we know that they're going to come up to New York, they can refer cases directly to us. Okay, I'm going to do 2 more questions, and then I'm going to move on to the next section. Margie.
So if I'm trying to do PSG for a client whose family has been involved in a blood feud,
Yeah.
and this is, I don't know that, is hearsay allowed in for, in order to prove that this actually happened? Because I don't know that I'll be able to actually get documentary evidence
Yeah.
for primary testimony.
Great question. So the question is hearsay allowed in evidence in an asylum application, or what kind of evidence should we anticipate submitting? Of course, if you have the option of getting a declaration directly from someone involved in this feud between the client and the family, that's, great. That's very persuasive. But the client's own testimony should be enough. So as long as the adjudicator finds that person credible, if they're testifying to issues related to their persecution, that can be enough. I like to supplement it, of course. In immigration court, the federal rules of evidence do not strictly apply. So yeah, so that's something to know. I mean, and of course at the asylum office, we're not in court at all, so sure, bring on the hearsay, but the federal rules of evidence are essentially persuasive, but they don't have, like, the judge can ignore them if he or she so chooses. So, but, as close to direct evidence as possible is the gold standard. And you had a question, yes?
Just quickly, is on the PSG for families, are uncles included, or is it only?
So, yeah, great question. Are uncles included in the family PSG? Unclear. We would have to argue, you'd have to go through the prongs, right? If the kid lived with his uncle, then sure, maybe, because that's like a nuclear family. Maybe you're going out to dinner, you're going to church, or wherever you're going with your family. Maybe you could show the 3 prongs there. And especially in cultures where, multiple levels of extended family live together, or maybe even on the same compound, that's persuasive, right? So you'd want to look into what's the custom in that area. Is it common for extended family members to all live together? If it is, you'd want to include that information as evidence of the social distinction prong. So I don't think there's a straight yes or no answer. It depends on context, but you'd have to make the argument. Yeah. Okay, so I'm going to pause on questions there because I want to move on to another form of legal relief that many of our clients are eligible for, and that's special immigrant juvenile status. So SIJS, as it's abbreviated, is a special immigration status that involves determinations made by state courts, interestingly. So it's essentially a bifurcated adjudication system where the federal government has said, okay, certain kids need protection, but we, the federal government, the legislators making these laws, don't know anything, really. I mean, I think in their wisdom, this was really smart, don't necessarily know anything about what the best interest of the child means. So we're going to bifurcate the adjudication system and let state courts make certain important determinations that then the federal government will analyze and decide whether the child actually qualifies for this immigration status. So there's federal statutory authority here in New York State. So a lot of this, because it's a bifurcated state and federal system, it obviously depends on the state law where the child resides. So I'm only going to be talking about New York State authority here. I'm not talking about New Jersey or Connecticut. But the relevant authority is the Family Court Act, the Surrogates Court Procedure Act, and New York Civil Practice Law and Rules, the CPLR. Okay. So the federal statute says that in order for someone to be designated a special immigrant juvenile, the applicant must be under 21 years old, and this tracks actually with the definition of child in immigration law. So under the INA, for a variety of different types of benefits, a child is someone who is unmarried and under the age of 21. Okay, so that tracks. He or she must be unmarried. He or she must have been, this is a very important definition, declared dependent on a juvenile court, and I'll explain what all this means, or they have to be in the custody of an individual or an institution appointed by the court. So basically, what that means in New York is a family court is taking jurisdiction over the case of a young person. Okay, the applicant also has to show that they cannot reunify with one or both of their parents. That reunification is not viable due to abuse, neglect, abandonment, or a similar basis under law. And they have to show that it's not in the best interest of the minor to return to his country of nationality or last habitual residence. Excuse me. So those are the 5 prongs that someone must articulate in order to be granted special immigrant juvenile status. Oh, that was a silly animation. Okay, there we go. So what does it mean to be dependent on a juvenile court? Well, in New York, there are many ways that a young person can be dependent on a juvenile court. For example, if ACS, the Administration for Children's Services, has moved to terminate someone's parental rights under an so-called Article 10 proceeding, that child is definitely dependent on a juvenile court. If a child is in delinquency proceedings, but most importantly, for our purposes, if the child is in guardianship proceedings or custody proceedings, that would make a child dependent on a juvenile court. So let's talk about guardianship. What is a guardian? It's anybody over the age of 18 that the court appoints to have responsibility over the care and custody of a minor. So this is someone who can make medical decisions for a minor, who can help the child make educational decisions, and basically anybody can become a guardian. So you don't have to have legal status in the U.S. for a New York court to appoint you as a guardian. So undocumented people can and are routinely appointed as guardians. The benefits for the guardian are that they have a piece of paper that says that they're in charge of this child, essentially. They can help the child do things like enroll in school, obtain a passport. There are certain consulates, specifically in Central America, that won't issue a passport unless both of the child's parents sign on. So if one of the parents is gone, we don't know where they are, the consulate simply will not give that child a passport unless they have a court order saying, hey, the parent who remains, or this aunt who's been appointed a guardian, is in charge of this child, you can issue the passport. Benefits to the child are that they are assured of having the care and the guidance of an adult. This is especially important with for a lot of our clients who have gone through, major traumatic events in their lives. Maybe one parent is not around, maybe they're abused, or suffered some kind of trauma. It is emotionally important for them to have to go through this legal process in many cases, because it shows them that someone will be looking out for them. They get a clear document that can help them navigate these bureaucracies. So there are a variety of benefits for a child to be appointed a guardian. Something else I should note is that a guardian, do I say this on this page? No. A guardian can be a biological parent, or it can be someone else. It can be a family friend, a pastor, an aunt, an uncle, as long as they're over the age of 18 and the court finds that it's in that child's best interest to have that person as a guardian, they will appoint that person as a guardian. Another point is that in New York, someone can have a guardian appointed up until the age of 21. So the New York State Court has said, young people, even up until the age of 21, often need adults to guide them and help them. Therefore, the New York State, the Family Court Act was actually amended to allow guardians to be appointed up until the age of 21. Okay, what is custody in New York? This is usually reserved for biological parents. So usually someone who's appointed a custodian is the biological parent of a child. It's only available up until the age of 18. So if a child is 19 and lives with their biological parent, custody is not an option, but guardianship is. So it's, if someone is not the child's parent, they're probably not going to be appointed a custodian absent extraordinary circumstances. So again, usually it's a biological parent going into court requesting custody of their own child who is under the age of 18. Okay, so then we have to think about, so that's the dependency prong. Let me just go back here. So we just analyzed what it means to have a child declared dependent on a juvenile court, or so that's guardianship, or be in the custody of an individual appointed by the court. That's a custodian. Okay, so we've met that. Now we have to analyze, so these two, let me just quickly say, these two are pretty easy to prove, right? Is the child under 21 years of age? We can look at their birth certificate. Is the child unmarried? The child can say, I'm not married. Great, okay. Now we have to analyze whether they can reunify with one or both parents due to abuse, abandonment, neglect, or a similar basis under state law. So say a child has gone into court, they live with their aunt. The aunt says, I want to be your guardian, I want to help you and guide you, and it's important that we have a legal document outlining that relationship. So they go into court, they get a guardianship order. They can then ask the family court to issue a subsequent order that outlines all of these prongs. So that's when the court is going to be looking at the birth certificate. The client will be asked on the record, are you married? No, great, okay. Is the client declared dependent on a juvenile court? Yes, clearly by virtue of the guardianship proceeding. Then the family court judge would say, okay, let us analyze whether the child can reunify with one or both parents due to abuse, abandonment, or neglect. So we look directly to state law on abuse, abandonment, or neglect. Again, federal law does not have, these definitions don't exist. So we are looking to state law for that reason, because that's the only place that we could get any guidance. So New York defines abuse as a situation where a parent creates or allows to be created a substantial risk of physical injury. It's a pretty straightforward definition. So if the child is physically abused and that caused physical injury or a substantial risk of that, that is abuse. It includes what's called passive sufferance of harm. So allowing a biological parent allowing someone else to physically abuse the child could itself be abuse. Okay, what is neglect? A neglected child is one whose physical, mental, or emotional condition has been impaired or is in imminent danger of being impaired. So what does that mean in case law? There's a ton of case law on what constitutes neglect in New York State. But if one parent abuses the other parent in front of the child, that's neglect. Verbal or emotional abuse is, interestingly, classified as neglect, not as abuse. And then, of course, like failing to feed the child, clothe the child, though financially able to do so, that's neglect in New York State. So if a child has suffered, facts similar to this, a judge in family court might find that they've been neglected. What is abandonment in New York State? It's where a parent evinces an intent to forego his or her parental rights, basically by failing to visit the child, communicate, or provide any type of support for the child. So there are, and the definition is in the New York Social Services Law. Interestingly, even if a child maintains some phone contact with their parent, that's not enough to defeat a finding of abandonment. So if the parent is not supporting the child at all, financially, really emotionally, they haven't supported them in quite a while, the child hasn't seen them, visited with them, but they occasionally talk on the phone, maybe the child feels obligated to do so, the court could still find that the parent has abandoned that child. I'm going to take questions at the end. So those are the definitions of abuse, abandonment, and neglect. The federal statute also has this other, I'm not going to call it a catch-all phrase, but an additional phrase that says that if the child can't reunify with one or both parents due to those three things or a similar basis under state law, they could qualify for SIJS. So it's really up to the states to define what this means. In New York, the most common scenario is where a parent has passed away. So in that situation, the child is analogized to a destitute child who has no support from that parent, of course, because they are deceased, but for the intervention of their guardian, would be destitute. That qualifies them for this similar basis under state law. So there are other examples, for like where a parent suffers from mental illness, is incarcerated, that could constitute a similar basis under state law. Okay, so we have gone through the definition here. The child has gone into family court and requested that a family court judge appoint a guardian or a custodian for them. And then they've also asked the judge to please issue me, in addition to that guardianship or custody order, please issue me something called a special findings order that specifically articulates these 5 findings. So there has been, filings, there's affidavits have been filed that attest to the facts underlying the allegations, underlying the abuse, neglect, abandonment allegations. That affidavit probably includes some information about why it's in the child's best interest to have the guardian or the custodian appointed. And then there's what's called a merits hearing in family court where the child will actually appear before a judge with their proposed guardian or custodian, and you as the attorney and the judge really can ask additional questions of the child to supplement the written record. So the child will testify orally as to the facts articulated here, and the proposed guardian or custodian will likely also testify. The family court judge wants to know, is this person going to be a good guardian or custodian? Is it in their best interest to be appointed? Is the child safe in the home? And what exactly are the facts related to abuse, abandonment, or neglect? The judge is making the final determination as to whether abuse, abandonment, or neglect actually occurred. So if the child is testifying to facts that don't meet those standards, the judge won't issue the order. If they do meet the standards, the judge will issue the order. Okay, so you have now walked out of family court with your shiny new guardianship order, custody order, and your shiny new special findings order. What do you do now? Well, you file a SIJS petition with U.S. Citizenship and Immigration Services. So USCIS is the benefits arm of immigration. Even if the child is in removal proceedings, appearing before an immigration judge, you still file the visa petition with USCIS. The judge has no authority to grant or deny a SIJS visa petition. So you file something called an I-360 petition. There's no fee. You file a bunch of different documents with the petition, including the family court orders and the child's birth certificate. You have to file, USCIS must receive the visa petition before the child turns 21 years of age. Extremely important. Okay, so then what happens? If the child is from a Northern Triangle country, Honduras, Guatemala, El Salvador, and even Mexico, the child waits. Why do they wait? It's taking USCIS a very long time to adjudicate these petitions. There's a statutory limit on the amount of time that they're supposed to take. It's supposed to be 180 days, but they routinely blow by that deadline. So we've had SIJS petitions pending for a really long time. The other issue is, say we file on a Tuesday, and on a Wednesday we get an approval from USCIS. They've looked at your petition, it looks good, all of your, all of the facts are articulated in the orders, the adjudicator can see clearly that the child is eligible for SIJS under the federal statute, and they approve it. Amazing. But if you are a child from Honduras, Guatemala, or El Salvador, there are not enough visas to go around. Congress sets the number of visas. It's based on a complicated algorithm, but basically there are only a certain number of visas available per country per year. It comes out to 695 SIJS visas available per country per year. Now, if you're a SIJS applicant from Nepal, I doubt that there are 700 SIJS applicants from Nepal, and I'm just guessing, but in any given year, I just don't think they're gonna meet that number. If you're from Honduras, El Salvador, Guatemala, there are certainly more than 700 kids applying for SIJS per year, so you have to wait in line. So kids are waiting in line so that a visa is available to them. In order to file for your green card, you have to have your visa approved or approvable, and there has to be a visa available to you. So if there's no visa available, if all 700 visas have been used up, you're gonna be waiting in line. You can't just go ahead and apply for your green card, unfortunately. At the moment, the wait is in years. We're quite backed up with the number of SIJS applicants that exist from the Northern Triangle. What that means is for kids in removal proceedings, judges, at least in New York, are saying, okay, you're in removal proceedings, you've told me that you're eligible for SIJS. It seems like you are eligible for SIJS. I'm looking here at the family court orders. I know that you filed your visa petition, and I know that there's no visa available to you. Hopefully what the judge will do is say, I'm gonna put your case, your removal case, on something called the status docket. So what that means is the case is active, but basically shelved. You have to update the judge periodically on case developments. If, suddenly USCIS revokes, they've previously approved the visa petition and you're just waiting for the physical visa, and USCIS suddenly revokes the visa approval, you're gonna have to update the judge, but, hopefully you're just kind of sitting and waiting for a visa to become available to this child. So even though they're not gonna get their green card immediately, neither will they, hopefully, be deported immediately, right? They're just gonna wait for a few years until a visa is available to them, and then they can terminate their removal proceedings, and then they can file for their green card application. It's important to note that, in the middle of all this, kids are not eligible to apply for work authorization. So usually work authorization is tied, in cases like this, work authorization is tied to an asylum application. You can get work authorization if your asylum application has been pending for over 180 days. Or you can get your work authorization if you have filed your green card application. It's called your application to adjust status. If you don't have an asylum case and if you are not able to file to adjust your status because there's no visa available to you, well, you don't get work authorization in the meantime. So that's an unfortunate reality that many clients have to live with. Even though they're 17, 18, 19, they're not able to get, an after-school job or, help pay for college because they're not allowed to file for work authorization. Okay. There have been new issues recently with USCIS adjudications related to SIJS petitions. So we went through the statute. It's a very clear federal statute that says that special immigrant juvenile is someone who is under the age of 21. And like I mentioned, that tracks with the immigration definition of a child. It's someone under the age of 21 who's unmarried. And I also mentioned that New York Family Court can take jurisdiction over the case of a young person if they're between the ages of 18 and 21. So a family court can hear a guardianship proceeding, and the child can be deemed dependent on a juvenile court, even if they're 19 or 20 years old. So why is USCIS denying or attempting to deny I-360 petitions for young people who are between the ages of 18 and 21? I couldn't tell you, but it's happening. We are seeing a lot of, they're called RFEs, requests for evidence, or notices of intent to deny, or flat out denials. And the rationales for all of these, in my opinion, are legally specious. So I will describe some of them. We have had RFEs where we've been asked to prove that the family court is a juvenile court. Please submit evidence that the New York State Family Court is a juvenile court. Okay, so then we go through the legislative history of the family court, and it has exclusive jurisdiction over issues related to the best interest of young people up until the age of 21. It was amended the Family Court Act was amended in 2008 to extend jurisdiction up to age 21, et cetera, et cetera. We have seen RFEs, NOIDs, denials that say, well, we know that the guardian of the child was granted guardianship, but that person wasn't granted physical custody, and therefore the court didn't have jurisdiction to make determinations about whether the child can reunify with their parents, which is kind of a word salad mess of a denial that we go through step by step and show why USCIS's interpretation is wrong. And then my favorite one is that the orders from family court were, it's not clear that they were issued in accordance with state law. I don't know what other law they were issued in accordance with, if not New York state law, but we've had to show, family court judges can only rely on state law. If they did otherwise, that would likely be in violation of a whole host of laws. So basically, at the moment, USCIS is narrowing their protests. They're focused now on the fact that USCIS does not think that kids between the ages of 18 and 21 qualify as dependent on a juvenile court, even though that determination is supposed to be left to the states, and even though New York State has said unequivocally juveniles between the ages of 18 and 21 are dependent on a juvenile court. So we've developed a lot of materials to combat these requests for evidence. What happens is, we'll file a visa petition for someone who's, say, 19. We might get a request for evidence, and then we'll respond to that. We have samples all ready to go. Maybe then after that, they receive our response. USCIS issues us a notice of intent to deny, which is like, we haven't denied you yet, but we're about to, so give us your best arguments. So we do. And then maybe we get a denial, so we appeal it to the Administrative Appeals Office. And then if the AAO does not agree with us, we will appeal to federal court. We haven't gotten here yet, thank goodness. Most of our cases that have been denied are here, and that's true of other advocates as well. We haven't seen a ton of denials from the AAO. But interestingly, there are 2 federal class actions that are ongoing that allege violations under the Administrative Procedures Act. So basically that USCIS, and I should note, these RFEs on these issues they have basically all come about under the Trump administration. So the argument here is that there are violations of the APA, that the change in policy is arbitrary and capricious, and that an agency is acting ultra vires, not under color of law, but they're making their own determinations and adding regulations and rules that don't exist in the statute or in the actual federal regs. So it's really interesting. The California case In the California case, the judge actually issued a preliminary injunction against USCIS, saying that USCIS can't continue to deny cases like this for these reasons in that district. The case in New York, the judge recently certified the class, so that's a step, and there are oral arguments on Monday, in fact, at 500 Pearl Street. So I will be there listening. I will be there listening attentively to oral arguments in that case. I fully expect that now, once we're in a federal court, that a judge will make the right decision and recognize that a lot of these denials are legally unsound. The federal statute is very clear. So it is, we have spent a lot of time and resources developing responses to these denials, and I am fairly confident, I'll just knock on this, but I'm fairly confident that a federal judge will, agree with the petitioners in that case. Okay, so I mentioned this, but once there's a visa that is approved and available, so there's a physical visa ready for the kid, then they can apply to adjust their status to that of permanent resident. Interestingly, so when most people apply to become permanent residents, you have to make sure that they don't have any other grounds of inadmissibility. So one of the most common grounds, I don't know if it's the most common, but a common ground of inadmissibility is, if you've worked without authorization, you will not be admissible to the United States as a permanent resident. That ground of inadmissibility is explicitly carved out for kids who were granted SIJS petitions. So even if a child doesn't get their work authorization and they do take, an after-school job off the books, that is unlawful, but it will not prevent them from ultimately getting their green card. Illegal entry is another ground of inadmissibility, or it's the unlawful presence that you accrue after your illegal entry. That also doesn't apply to kids who are granted SIJS visas. So that's something to know that, if you have a child with grounds of inadmissibility that you're concerned about, you can check the statute to see if there's a carve-out. So this is a visualization of the SIJS process. I didn't make this, so I would extend this a bit just to account for delays in USCIS adjudication and the amount of time it's taking for visas to actually become available. Excuse me, but you can see here, here's the process. A child is apprehended at the border. They're released to a sponsor. At some point, they walk along here, and then the NTA is lodged, and they go to immigration court. And then somewhere around here, they can start it here. It doesn't really matter. They don't have to go to immigration court first, but somewhere around this area, they can go to family court and request that their caretaker be appointed their guardian or their custodian, and ask the family court judge to issue that order with the 5 special findings. That's filed with USCIS. And then at some point, that's adjudicated. Hopefully it's a grant, and then at some point later than that, the visa's available. Then immigration court will terminate the removal proceedings, and then the child can file for adjustment of status. I just want to note, so the issue where visas are not available, like I said, that is certainly the case for kids from the Northern Triangle of Central America and for Mexico. It is not the case for other countries. So if you do have a client from, say, Jamaica, you could conceivably file your I-360 petition and the adjustment of status application at the same time. USCIS will accept it's called a concurrent filing. They'll accept both of those at the same time because there's no visa backlog. There should be a visa available for a Jamaican kid. So they allow you to file it together. That means that the child can also, at that moment, get work authorization. So the limitations on visas are only for countries that are so-called oversubscribed, where there are too many people applying for the visas and there are not enough. But for a country like Jamaica, or I gave the example of Nepal, they could probably file simultaneously. Okay, so a quick hypo and then questions. Lucia, I'm just going to read it aloud for the sake of the video. Lucia is a 19-year-old from Honduras who entered the U.S. alone when she was 17. ORR released her to the custody of her aunt. Before coming to the U.S., Lucia lived with her mother and her mother's boyfriend in her home country. So Lucia worked as a maid for several years before coming to the U.S., but she gave all of her money to her mother. Lucia attended school for a few years, but she can't remember when. And she said that her boyfriend's mother sexually assaulted her. When Lucia told her mother, the mother didn't believe her, called her a liar. Okay. Lucia has never known her father. Her mother doesn't talk about him, but he is on her birth certificate, and Lucia is now living with her aunt in the Bronx, where she feels safe and happy. So take just 30 seconds and let me know if you think that based on these facts, Lucia qualifies for special immigrant juvenile status. Oh, thank you so much. Oh, great. Okay. Oh, excellent. Okay. Yeah. Well, thank you so much for coming. Okay, everybody. So what do we think about Lucia? Does she qualify? Yeah. Perfect. So she's under the age of 21, right? And I recognize, I just gave you the whole spiel about USCIS denials between the ages of 18 and 21, but let's assume that USCIS does the right thing and grants it. So she's under 21. Is she unmarried? I'm going to say yes. I don't know. We would have to ask her that specifically, but there's no fact to the contrary, so let's go with yes for now. Is she dependent on a family court, or has she been placed in the custody of an individual or an institution? Not yet, right? But she could be. She could go to family court and say, I'm 19, I'm new to this country, I need someone to help me make decisions, I want my aunt to be my legal guardian, right? So then we get the dependency prong, great. Okay, can she reunify with one or both parents, or is that reunification not viable due to abuse, abandonment, or neglect? What do we think about that? This is the meat of it.
Not viable.
What's that?
I would say not viable.
Right, I agree with you. On what grounds specifically? Let's do mom first.
Well, I don't know if it would come under neglect or abandonment, but it's going to be one of those
Yep.
two things based on the definition you gave.
Right, exactly. So mom, I think we definitely have a neglect argument. Lucia stopped attending school. She was working as a maid. She gave all the money to her mom. And mom also didn't help her when the boyfriend sexually assaulted her. That, I would actually go into family court and argue abuse there as well because of the passive sufferance of harm definition. So that's a possibility. And then abandonment, mom hasn't been taking care of her recently, and in fact, arguably wasn't taking care of her before, right? So I totally agree with you on that. And then, can she reunify with dad due to abuse, abandonment, or neglect? I see people shaking their head no, right? On what grounds? Yeah, I agree. That's abandonment. Okay, so we hit that prong, and then we finally have to show that it's not in her best interest to return to her country of nationality or last residence. Do you think we can show that to a family court judge? People are nodding, I agree. The best interest standard in New York is pretty broad. So as long as the judge takes into account basically all relevant circumstances, there is plenty of case law that would support a finding that it's not in her best interest to return to Honduras, where she would not get an education, doesn't feel safe, was working and not getting any of the money. Whereas in the Bronx, she does feel safe and happy and wants to pursue her education. I think we're in good standing there. So we've hit the 5 prongs. I think a judge would also find that it's in her best interest to have her aunt appointed as her guardian. So I think we're good there. I think we walk out of family court with 2 orders. I think we file those orders with USCIS. And hopefully, USCIS gets an order from federal court saying you better start granting these for kids between the ages of 18 and 21. I think that'll happen. Okay. We have a few, we don't really have time to go into this, but there are a few developments in immigration law that are relevant to children, specifically a BIA case called Matter of Mako. I described the UAC filing procedures where if a child was designated a UAC, at the border, that designation is supposed to stick with them so that they can file with the asylum office. But Matter of Mako, like I said, says that once a child turns 18, that designation is done. So an 18-year-old former UAC has to have a trial before the immigration judge according to this case. I discussed Matter of AB. You've all seen in the news separated families and related litigation. Safe Passage was heavily involved in that effort. We represented over 60 kids who had been separated from their families and shipped up to the New York area. And we were involved in the subsequent litigation and settlement agreements. There are ongoing issues related to how and where people can file for asylum. So I feel like every week there's a new issue, a new case to follow. That's it for me. Any final questions on special immigrant juvenile status? Yes?
This is more of a general
Sure.
question. So when you get, a client,
Mm-hmm.
Do you know right away whether you're going to file for asylum or special immigrant juvenile status, or is it just whichever is the better argument?
Yeah, great question. So when Safe Passage meets the client, we do a comprehensive intake. At that point, we assess the client for eligibility for relief. So a senior staff attorney is making a decision as to what we think the best possible outcomes are. So it's possible that a client would be eligible for SIJS and asylum, in which case we would recommend to the pro bono to apply for both. It's possible that, you definitely can. So it's possible that a child is not eligible for SIJS for a variety of reasons, so we'd only go with asylum. And then it's also possible that as you're working with the child, that you're going to get more information that supports a finding, or that supports filing one or the other that you didn't realize before. So it's shifting, but we usually have a pretty good sense after the intake, and we can certainly apply for both. Yes?
I'm tacking on to her question, which is do you find for Safe Passages one more tend to be more successful than the other?
I don't know the answer to that anymore. I used to have, feelings like I could tell what a successful asylum case would be. I don't have that feeling anymore about asylum because the law is changing. So it really does depend, I think, on the adjudicator and how much evidence you can get. I still feel...
Statistically,
Oh.
how does it come down? Or are they about the same, or is one?
I don't know the answer. I would say maybe like 60-40 SIJ asylum, but I'm not positive. And then I used to think, SIJ was guaranteed for anybody up until the age of 21 because that's what the statute says, and that's not where we are right now. So I don't know. Yes, and then you. Yes.
I have a question about the juncture at family court. You mentioned quickly about neglect and sort of an exception if neglect is due to poverty.
Yeah, so the idea is it's neglect if someone had the financial means to pay for a child's food or education or clothing, and they failed to do so.
Does the family court ever look into that? We just did a SIJ petition, but we inherited it after that juncture, so another attorney had already done all that. But it's clear, it's just obvious, of course, that the mother is poor. I mean, the situation wouldn't be.
Yeah.
So my question is, will the court ever look at that and say, wait a second, of course your mother neglected you. She's living in poverty in Honduras.
Yeah.
I mean, and is that ever something you consider?
Yeah, the legal definition is it's right in the statute. It's if they had the financial means to do so. So I would expect the judge to ask questions related to that. But it's possible that there were other forms of neglect that kind of occurred around that. So like we have, for example, clients who grow up in extreme poverty, okay? I wouldn't necessarily argue that their parents neglected them simply because they weren't able to get enough food or didn't have sufficient clothing, because it's not like the parents were purposely not paying for that kind of stuff. But if the parents paid for any other type of, like entertainment or non-essential item, and the child went hungry, well, then we've met, I would say. You have an argument for actual neglect. And we have situations where children are essentially forced at a very young age to engage in child labor in dangerous situations. So that goes beyond just not providing food. That's affirmatively putting a child in a dangerous situation. So there are other kind of related questions that I would want to ask. But yeah, I mean, the definition is relatively clear, but the facts sometimes are not.
In your experience, you haven't seen judges probing that?
No, I have. No, that's what I'm saying. Yeah. No, I definitely have. Yeah, yes. Oh, no, I'm sorry. You first and then.
Just real quick, have you been noticing specific judges or specific courts where they've been raising these new issues, denying petitions? Like, I obviously don't make names, but is there sort of a tendency, a trend line that you're seeing among certain judges?
I don't think we've had enough, like specifically for asylum trials.
Either one, when you would call attention to the changes or recent additions to
Right.
trials of SIJS or...
So the judge isn't making the SIJS determination, so I can't really say. The USCIS is making them, and they are consistently denying if the child is over the age of 18. So that's just like USCIS policy from the top down. In terms of asylum adjudications, which are or can be in the purview of an immigration judge. Yeah, I mean, certain judges have, certain feelings about different types of claims, but I don't know that maybe you can ask me later if you were before a specific judge, but it's hard to say. I mean, it just depends. It should depend entirely on the facts of the case. I think that there are certain judges certainly who are more skeptical of certain types of claims than others, but not to any extent that I can say, like, this judge is 100% going to deny a case involving XYZ because it's supposed to be truly a case-by-case determination. Yes, sir.
Out of curiosity, how long has the visa quota system been for those for Central American countries been in effect?
So the quota system is always in effect, but it's been oversubscribed. I don't know exactly, but I think since 2015. So you saw, I think maybe at the beginning of the presentation, how the numbers jumped from kids from Central America coming to the U.S.-Mexico border.
Very interesting, because I finished a case for time just before that.
Mm-hmm. Yeah.
Which was not only smooth sailing compared to
Right.
fighting a whole bunch of procedural glitches and nothing to do
Right.
with the kind of obstacles you just mentioned.
Right. So the question is really like it's two-pronged, right? It's like how many kids are in the country who qualify for this? And after 2014, 2015, the numbers from Central America went up. Many of the kids fleeing qualify. And then the question is subsequently like how many are actually applying? And if it's more than 695 per year, then we're going to be stuck. The country's going to be oversubscribed. The visa category will be oversubscribed and we'll be stuck in a backlog. Yeah, so I would say the timing works with your experience. Other questions? SIJS, asylum, immigration law, life? No. Okay, so I'm gonna just say a code for the video for people who are required to watch this. The code is 1238. You don't need to know this code. It's only for people who are required to watch this video. It's 1238. And if there are no other questions, I will say thank you very much for, one more question, yes?
Where would I go? Are these slides available? Where would we get?
The slides themselves are not available, but I should have mentioned, thank you for bringing this up, we have extensive resources on our website. So we have a SIJS manual, an asylum manual that describes in great detail, everything that I've mentioned here, and then really the procedural steps to take in each case. So please visit our website under the resources tab. Okay, that's all. Thank you.